Hi friends, did you know that there is a plea under the law of contract called economic duress? Have you heard about this? Economic duress is an English proposition under the law of duress. In India, we call it the law of coercion. However, duress is considered broader than coercion under the Indian law, and duress could mean either physical or non-physical. In 1979, in the Atlantic Baron case, the English courts did evolve the concept of economic duress, wherein they said that there are a couple of components that are to fulfill before a contract can be initiated and to be held to be voidable on the grounds of economic duress. First and the foremost, there has to be a threat by one of the contracting parties not to perform the contract. Two, the threat should be an illegitimate threat. It should be an unreasonable, illegal threat. And three, the threat should have been acted upon and thereby resulting in a loss to the contracting party. In India, over a period of the last couple of decades, the courts have been pleaded with the concept of economic duress just beyond the concept of coercion as defined by the Indian contract law to substantiate that can a contract be set aside on this ground. Now, very recently, a couple of days back, there was a matter before the Delhi High Court in a case called Union of India versus B.S. Sangwan. In this case, it was the government that was alleged to have committed economic duress because what happens with the government is very often than not, like in this case, they do release payments to the contractors. But before the final payment can be released, they have a printed kind of a receipt. This is called the no claim certificate, which means that you shall be paid if you declare, sign that you have no further claims against the government of India. This is a standard document. It's a standard format in which the accounts or any other department of the government gets the signature of the contractor and the vendor, and the contractor and the vendor then have to sign it. If they do not, then the payment is not released. And hence, once the contractor has signed this no claim certificate, can he still prefer a claim of damages if he has not been paid adequately enough under the contract, or whether if there is a kind of a dispute or difference between the parties regarding the payment terms and conditions after having given the no claim certificate. The Delhi High Court has recently come to this conclusion that any pre-printed receipt such as the no claim certificate, when it's signed and given to the government by the contractors and the vendors, of course, is given under economic duress because there is no other option. Because please note, the government is using this as a threat, and it's not a legitimate kind of a threat that you have to say, I have no claims. Right? I think that kind of threat is not admissible, and the no claim certificate will have no validity whatsoever. And the contractor can definitely raise additional claims if he feels that disputes and differences still arise from such kind of a contract. I think this is a welcome move from the courts in India to bring in the concept of economic duress between those kinds of parties that have an unequal bargaining capacity. And we have already seen that such kind of economic duress does exist in standard forms of contract. And hence, from B to C kind of a contract, now evolving the plea of economic duress in B2B, or what we call as B2G, that is business to government contract, is a welcome move. And I think this is something that we all should be able to appreciate in our contract law classes.